First of all, in my view, the three laws that were enacted, they were enacted without any proper discussion in the parliament. That is the foremost objection. You see, suppose we argue a case, judge doesn't hear us. Let him decide whatever he wants. But the judge should listen to us. But 146 MPs were placed under suspension. 146 MPக்கள் suspensionல இருக்காங்க. Nearly 1/3 of the house was suspended. And the laws were passed. What was என்ன சொன்னாங்க? What was the view? Why they brought these laws? The senior advocate has said, these laws represent colonial legacy. I don't understand. Really, I don't understand. Kindly read Article 13. Kindly read Article 13. It is not like USA. When 1776 they overthrew British rule, they said all the laws are overthrown. But it is not so in India. Article 13 declares all the laws made by British imperialism will continue to operate, still operates. You take, for instance, in Chennai, Madras City Police Act. You see, every day, District Police Act. உங்களுக்கு ஊர்வலத்துக்கெல்லாம் தடை யார் கொடுக்குறது? எந்த சட்டம் அதெல்லாம்? I think 1888. சரி, Civil Law, Transfer of Property Act, Indian Contract Act. Sir, hundreds of laws are still in operation in view of Article 13. Therefore, the legacy itself, the theory of legacy also is a fraud. And they said it's a colonial law. One among the three laws, Criminal Procedure Code, was already repealed and reenacted in 1973. How can it be called a British law? Therefore, what they did, they wanted to, weaponize the police. That is what I understand. Weaponizing police is two things. It is against the people, and for lawyers it is difficult to do practice. You can't get bail. Even now, you know, from Arvind Kejriwal to Senthil Balaji, people, even I may say, Mr. Chidambaram was in jail for 100 days. Morning. Maybe and that is why these three laws, these laws should be repealed. நம்ம தமிழ்நாட்டை பொறுத்தவரையில் lawyers are united, and I will proudly say lawyers are agitating in entire India. Tamil Nadu is showing the way. I think it should be taken to other states. It should be taken to every state. I think பக்கத்தில் உட்காந்து my brother, I think Clifton, he told me he's from Bangalore. And also I saw the invitation from Andhra Pradesh. I think the issue will be taken to everywhere. There should be a powerful struggle, agitation against this government. If there is agitation, definitely we will succeed. The agriculturist, you see, farm laws were thrown out by agitation only in Punjab, in my view. But that law was scrapped by the government itself. Therefore, முடியாதுன்றதில்லை. என்ன கேட்டீங்கன்னா முடியும். டெஃபினட்டாக தமிழ்நாட்டை மட்டுமே நிறைய காரியங்கள் நம்ம சாதிச்சிருக்கோம், முடியும் அப்படின்றத என்னுடைய கருத்து. இதில் ஒன்று ரெண்டு விஷயத்தை சொல்லிடுற அவர் சீனியர் அட்வொகேட் said about EMS Namboothiri part. I was in Communist Party Marxist for a long time. Therefore, but only thing is that case didn't arise under sedition law. It arose under contempt law. I think contempt law has also to be scrapped. I don't know. Some journalists, N. Ram and Arun Shori, filed a case and later they, I think, withdrew. Or it is pending, I don't know. We are not entirely against contempt law. A portion of the contempt law. Sir, if direct interference in the court proceeding, it is a contempt. Suppose some people go into a room, quote all. They prevented the judge from doing his duty. It is a contempt, but not criticizing the judgment. Here, people are afraid of criticizing judgment. So, do you see? In papers, in any media, everyone is afraid of talking about the judgment. When it is my experience, they ask me, sir, no one is speaking against the judgment. Will you? Yes, I am willing to speak. If it is not correct, I will say it is not correct. And therefore, as far as contempt is concerned, it should be cut down, it should be reduced. Only when there is a direct interference, the court proceeding. And EMS, what EMS said, என்ன சொன்னார்னா, every person, be it a minister, be it a IAS officer, be it a IPS officer, or secretary to government, or a teacher, anyone has a class interest. He will decide in favor of one class or another class, a ruling class or oppressed class. No one is an exception, including judge, he said. That including judge, contempt proceeding was initiated. And Kerala High Court convicted, and Supreme Court confirmed it, but of course reduced the sentence. My memory, I think 100 rupees or 1000 rupees was imposed with 1 day. He has to sit. The funny thing about the judgment is, now he is no more. Both of them are no more. Chief Justice Idayatullah, he said, well, even one thing, our EMS Nambudri Bhatt சொன்னார்னா, he said, this is what Marx said. He did not say it is my view. This is, yes. அவர் என்ன சொன்னார், EMS, யாராக இருந்தாலும் அவர்களுக்கு ஒரு வர்க்க பார்வை உண்டு, அதற்கு நீதிபதிகள் விலக்கல்ல அப்படின்னாரு. அப்படின்ட்டு நான் சொல்லல ஐயா, அவர் கண்டெம்ப்லேருந்து எஸ்கேப் ஆகிறதுக்கு சொன்னாரா இல்லை என்னன்றது இல்லை, உண்மை அது. அப்படி என்று மார்க்ஸ் சொன்னார்னு சொன்னார். இதயத்துல்லா சொன்னார், அதான் அவர் கான்ஸ்டியூஷனை சரியாக படிக்கல, இஎம்எஸ் ஐபிசியை சரியாக படிக்கல, கண்டெம்ப்லாவை சரியாக படிக்கலன்னு சொன்னால், ஐ வில் ரியலி ரிகார்ட் இதயத்துல்லா செட், இஎம்எஸ் மார்க்சிசத்தை சரியாக படிக்கலன்னாரு. That is a joke. Part of it. That is what I wanted to tell our senior advocate. And two things. Before going to the 2-3, நான் 2-3 விஷயம் இந்த 3 சட்டத்தை சொல்றதுக்கு முன்னாடி அவர் சொன்ன அந்த 2 சேஃப்கார்டை பற்றி. 2 சேஃப்கார்டு இன் உப்பா. I think I want the UPA to be totally repealed, like all the 3 laws. என்ன கேட்டீங்கன்னா, ஏன்னா இந்த தடா போய் பொடா வந்தது. ஏன்னா தடா இஸ் a temporary act. It will be reviewed periodically, reviewed and scrapped, replaced by POTA. POTA also a temporary act. It was during Vajpayee period. After POTA, they brought, already it is 1967, it is toothless, this UPA. Now, 2004 and all Congress period, it was weaponized, made everything, they made worse during this this for last 10 years, even individual can be called a terrorist, whatever. They can frame you and no bail will be granted. In Tamilnadu, 1 or 2 lawyers from Madurai were denied bail for 2 years under UPA for conducting case for some urban nexus within court, urban nexus. He is a lawyer conducting for urban nexus. He is not urban nexus. He is a lawyer. அப்போ அந்த 2 safeguards என்ன? One is review. There is a reviewing authority. Number 2, there will be a sanction before taking cognizance. இந்த ரெண்டுமே இல்லைன்னு சொல்லி சாய்பாபா கேஸில் நாக்பூரில் இருக்கக்கூடிய செஷன் ஜட்ஜ் அக்விட்டட் சாய்பாபா. Unfortunately, in the appeal against acquittal, a stay was granted, he was not released. Now he died also. The Supreme Court sat on Saturday. Such urgent case. A person with 90% disability, he is waging war against India. That is the charge. Again, these judges gave stay. Ultimately, it came before a bench. They said they did not argue. You see, they said yes, remand it. Better be, instead of arguing before you, I will argue before the High Court. That is a confidence reposed in the Supreme Court. They said, I will go before the High Court. Again, it went before the Supreme Court said, decide on merits also. This time also, High Court said, as far as Sai Baba is concerned, there was no sanction prior to cognizance, and also there was the review authority order is something what a sham. No non-application of mine, no reasons are given. Besides holding on facts, no charge is made out. It is, I call it a honorable acquittal. That person was put in jail for more than 10 years. Therefore, those two safeguards are not available when UPA provisions are incorporated in BNS. That is a problem. And you see, now, as I said, 2-3 things I want to say. Police custody. Earlier it is 15 days. Now it is to 60 or 90 days. What is the difficulty? I will tell you, I am not a serious. Now, I wanted to raise my hands when he said, who was practicing in labor law? I was practicing in labor law for all the 29 years. But I did practice on the criminal side. But though I was a junior to a senior advocate, practicing exclusively criminal law for some time. And police custody 15 increase pandradhula as a judge I will tell you an example. A magistrate in Thoothukudi jurisdiction, a magistrate, what is a murder of a mafia. He said, அவன் பேரில் 1000 complaint இருக்கு. That he was as a condition he was signing in the police station. When he came out, he was murdered and many accused were roped in. All 2 accused surrendered before the court. And police wanted police custody for those 2 persons. After the counter affidavit, hearing the parties immediately, judge declined police custody to 1 person, granted police custody of a day or 2 for other person. Against this order, a 482 petition was filed before a High Court. High Court said the judge committed grave error in not granting police custody. I am helpless because now 15 days is over. And directed the judge, the registry, to take action against the magistrate. I was a portfolio judge. I am not a serious criminal. I am not a criminal lawyer. Then I looked into entire papers. I said, drop the charges. I said, drop the charges, giving reasons. Because the other accused said, I am a practicing advocate in this court. And I have filed a case against the investigating officer in my personal capacity. Therefore, if I am taken to police custody, what will happen? Therefore, the judge felt police custody is not required. The brilliant criminal side judge, did not look into it. He said, take action against the magistrate. I said, drop the charge. Because I have that authority, because I am the portfolio judge. That is why the police custody for 5 நாளுக்கே இதான் பிரச்சனை. இப்போ 90 நாள்னா நான் விட்டு செய்வான். கேப் விட்டு போலீஸ் கஸ்டடி கேட்கலாம். ப்ரெஷர் இருக்கிறப்பெல்லாம் கேட்கலாம். That is why I am saying they are weaponizing the police, giving more power to police. I think that is not good for in any democracy. Don't give more powers to court, not go more power to police. Give more power to people, not this police. Then, you see, Article 50 of the Constitution speaks about separation of power between executive and judiciary. Totally. That is why executive magistrates are abolished. Therefore, now Justice Gavai and Justice Vishwanathan said, in bulldozer justice, they said, no, you can't. Police or administration cannot decide a person guilty. It is the right vest only with the court. Court alone can decide. இங்க என்ன சொல்றாங்க? Police is given power to impound properties. You see, tomorrow properties will be impound by the police. See, he is accused. Ultimately, after 10 years, he will get acquitted. Till then, his property will be finished. என்ன ஆகுன்னு தெரியாது. And so many things. I think the issue of the civil liberties, it's inhuman to wear a handcuff. That is what Justice Krishna had declared. Now it is made a part of law in the amendment. Handcuffs are now permitted. Freely they can use it. And they also permits use of force to arrest. At the time of arrest, earlier also, they can use as for self-defense, suppose a particular accused. Now it may lead to encounter. I may say, now the act gives a power to police to use force for arrest. What he will do? After killing. He will say, I have no other option. That is why I am not giving any. From morning இதை நிறைய பேர் பேசியிருப்பாங்க, ஏன் இந்த 3 சட்டம் போகணும் அப்படின்ட்டு. அதனால் நான் இதான் தீஸ் ஆர் ஆல் த ப்ராடா so many இதே மாதிரி இஷ்யூ. செடிஷனை பற்றி சொன்னார். நவ் 124A இப்போ 152 வந்திருக்கு செடிஷனில். அப்போது when Chief Justice Ramana was dead against this, then they played a trick. They wanted to get out of it. They said, we will consider it. And the Justice Ramana bench, Chief Justice Ramana, then he recorded all the proceedings are stayed under sedition. Now again it has come with more teeth, as he noted, our senior counsel noted. And finally, I just make to say this. என்ன நான் சொல்றேன்னா, நம்மால் இதில் வெற்றி பெற முடியுமா? Could we succeed? Could we succeed? We will succeed. That is what I want to say. நம்மால் வெற்றி பெற முடியும், தமிழ்நாட்டில் வெற்றி பெற முடியும் அப்படின்றதுக்கு நான் 4 உதாரணங்கள் சொல்றேன். 1, in 1950s only in Tamil Nadu for entire India. நான் சொல்றேன் entire India, not for Tamil Nadu. Entire Indiaக்கு Article 15(4) was amended because of agitation in Tamil Nadu. But for Tamil Nadu agitation, there will be no reservation for education for SC, ST and OBC. This was the first amendment to Constitution when Ambedkar was a law minister. And Article 15(4) was introduced. And that is pursuant to a big agitation in Tamil Nadu supported by this ruling regime. The president of Congress was Kamaraj. They supported this move of Periyar. And that is why we will succeed. Article 15, no, will anyone tell? Initially, Nehru said, no, if Tamil Nadu alone is only raising voice. But ultimately, he was made to amend the Article 15(4). Second, it is not all over India. In Tamil Nadu, we succeeded in 2016 reversing a Supreme Court judgment. Supreme Court judgment said Jallikattu is cruel to animals. நமக்கு தெரியல யாருக்கு அவங்க சொன்னாங்க. Supreme Court judges interpreted Prevention of Animals to Cruelty Act saying the play with the bull இருக்கு பாருங்க, by in Tamil Nadu the traditional அந்த விளையாட்டுன்னு சொல்கிறது அந்த விதை they said it's a cruelty. ஏன்னா Prevention of Cruelty to Animals Act put 1, 2, 3, 4, 5, 6, I think section 11. What are all cruelty? Adala, they interpreted as a cruelty. The same act says the following are not cruelty. If you kill the animal to make biryani, it is not cruelty. I am seriously telling. The act says, if you kill animals, otherwise, however, non-vegetarian hotel will cook, or in the, I don't know what you serve during lunch. And therefore, likewise, the ஊர்ல குலதெய்வத்துக்கு ஆட்டுக்கடா வெட்டி மொட்டை அடிச்சா அது கிடையாது. they say அதே மாதிரி அனிமலுக்கு வந்து நீங்க if you iron rodல you put a mark that is not. I mean, they give a long list. Because of our agitation, now said, and the exception, it is not cruelty as far as Tamil Nadu is concerned for delicate. That was our success. அதோட எப்போ தெரியுங்களா, இந்தியாவிலேயே நான் நினைக்கிறேன் it is a concurrent subject. Cruelty to animals, prevention of cruelty to animals is in number 17, item 17 in concurrent list. Therefore, if at that time, and the Tamil Nadu Assembly was not in session, the agitation was going on. ஒரே நாள் உயிரோடு இருந்த அமெண்ட்மெண்ட், ஆர்டினன்ஸ் ஒரே நாள், அடுத்த நாள் சண்டே அன்னைக்கு, சாட்டர்டே அன்னைக்கு ஆர்டினன்ஸ், சண்டே, மண்டே அன்னைக்கு, இதோ தேர் வாஸ் a death of late Jayalalitha as a chief minister. வழக்கமாக ஃபர்ஸ்ட் டே no business will be transacted. Exceptionally, due to our agitation, first day law was enacted in Tamil Nadu for assembly. ஆனால் அதுக்கு முன்னாடி ஒன் டே தேர் வாஸ் ஆர்டினன்ஸ். இந்தியாவிலே ஒன் டே ஆர்டினன்ஸ் இருக்குன்னா அதுதான் நினைக்கிறேன். பிகாஸ் ஆஃப் தி அஜிடேஷன், பிகாஸ் ஆஃப் தி அஜிடேஷன் we are able to win over our right for ஜல்லிக்கட்டு by amending the act. நம்பர் 2, தமிழ்நாட்டில் இன்னும் 2 கேஸ் மொத்தம் 4 சொன்னேன். அந்த 2 வந்து லீகல் பேட்டில் ஃபார் ஆல் ஓவர் இந்தியா. லீகல் பேட்டில் all over India. What is that? That was also like that Jallikattu, the cruelty done by Supreme Court in the case. This in 1986, Supreme Court said there will be all India quota in medical seat without providing reservation. என்ன எவ்வளவு தெரியுங்களா? What is the percentage of reservation? All India reservation. No, 50% in MD and MS, post graduation. It's a fraud. What business the Supreme Court will have? It is for the legislature, parliament, and the 15(4). They have to enact law. But what they did, 50% in MD, MS. They said there's a communal cap for 50%, but they said 50% for MD, MS, 15% for MBBS. No reservation for this 50% and 15%. No state has fought it except Tamil Nadu. Tamil Nadu, a series of writ petitions are filed by every political party except BJP. And in Madras High Court allowed our writ petition. After, of course, this government resisted, but we succeeded. The benefit is now given to all over India. The benefit is given to all over India because of our legal battle. It is a legal battle. Of course, no one from every backward class or scheduled caste or scheduled tribe from all over India are the beneficiaries, not the Tamilians alone. And finally, our lawyer community is very frightened enough to say, it is CRPC now. Earlier it was CPC. When CPC amendments were made, there was big agitation in Tamil Nadu alone. Then it's a reported decision in Salem Bar Association case. We got so many reliefs, I don't want to describe. Therefore, what I say is, Tamil Nadu is a forerunner, torchbearer. Our lawyers, always, even either 2009 for Elam Tamil, there was our agitation, is a heroic agitation. At that time, I was elevated. I was very unlucky. I did not aware that not welcome by Bar Association. In 2015 and 16, you lawyers, first time in India, the High Court was Muttugai, seized. First time for your demand, saying that disciplinary power cannot be taken over from Bar Council to judiciary. Yeah, that to district judiciary. You know how caste system is operating in the rural areas. Therefore, what நான் சொல்றேன் என்னன்னா, நம்மால் முடியும், நாம் வெற்றி பெறுவோம். நன்றி, வணக்கம்.